Hello, everybody. My name is Claudio Novelli, and today I'm going to introduce this topic which regards the hypothesis of an autonomous legal status to AI systems, and if this is a good way for embedding AI system in the legal realm. First of all, let's start with what is like to be a person in law. Legal personality is a cluster concept, which means that there are different incidents and there are different situations, and those situations are not necessarily connected. We have two conceptions. We have a thin conception, according to which an entity is a person under the law if there is at least one rule conferring a right or a duty to the entity, and a thick one, such as an entity is a person under the law if it is addressed by a complex package of rights and duties. For our purpose, the major benefit of a legal personality is that it allows to confer a separate patrimony to AI system in theory, with which creditors can be secured in case of harms, damages, and eventually crimes. I think there are some good preliminary reasons for granting legal personality to AI system, even though it is not the only solution jurists have at their disposal. But I believe there is the most suitable solution for the next future generation of AI system. Why? First of all, autonomous agency. AI system can be autonomous in the sense that they are able to implement and manipulate and supplement initial knowledge provided by the designer when it proves to be incomplete or inadequate for the operating context. Second, accountability gap. Autonomous skills frequently correspond to a lack of control on the part of the human user, and this is crucial if AI systems are involved in legally relevant situations, as entering into a contract or other types of negotiation. In some other cases, the human agency is neither capable to predict the precise course of action an AI system will follow under changing circumstances. And this leads to a kind of accountability gap, such as the human user is held accountable for actions that she may not have wished to take or could not reasonably prevent it. And finally, the inadequacy of conventional liability models. For instance, if we take the case of tortious liability, the negligent supervision, which is one of the traditional model, the negligent supervision of the custodian is an unfeasible solution due to the autonomy of the AI system and due to the technical inability to foresee the specific behavior of an AI system. On the other hand, the alternative, which is strict liability, risks being unfair or at least too severe on the part of the human user. So these technical attitudes show that the risk arising from the use of AI system as they are currently designed is inherent in the way they work rather than caused by the negligence of the programmers or developers. Of course, some unfortunate events and consequences can be avoided with better standards of reliability, but coders cannot be expected to provide instructions for every single behavior under all circumstances so that every outcome would be determinate, unless by giving up the very idea of intelligent agents or dramatically reduce the degree of autonomy. I believe we should not renounce to the idea of developing autonomous artificial agents, and the risk of damages produced by reasonably unpredictable behaviors can be accepted for at least two reasons. The first one is an economic reason. Even assuming that perfectly predictable and trustworthy intelligent agents can be developed, there are trade-offs to take into account, such as the cost of producing fully transparent AI system is likely to exceed, at least in the short and medium term, the estimated gain, which is a disincentive to innovation and to the production of these systems. And side effects can also occur on the performance of algorithms. And then we have an utilitarian reason, such as despite this operational uncertainty, AI systems typically display a far greater capacity to decision making than humans. And this is an advantage that we should not renounce, we should not dispense with above a given safety threshold. So let's only think about AI, an AI system supporting medical diagnosis. Thus, we have preliminary motivation to consider the use, perhaps provisional, of AI system, even under suboptimal condition of predictability, and to design the best allocation of risks and costs of damages. I will therefore hold a weak thesis about the possibility of granting personality to AI system, as summarized by these points. Although AI systems have better decision-making skills, the humans, they may produce damages. Damages from AI are frequently unpredictable and create accountability gaps. Accountability gaps can be tackled either with or without the attribution of autonomous personality to the AI system, but in the latter case with unfair implication for human parties or disincentive to use of such systems. And finally, it can be presumed that conferring legal personality to a system produces advantages in terms of distribution of costs and simplification in imputation of legal effects. But even assuming a widespread agreement about the attributability of legal personhood to AI systems, I think there is a kind of coordination problem which correspond to three different kinds of asymmetries in legal regulation. First of all, a technological asymmetry. Each AI system can perform very diverse tasks with variable risks, autonomy, and social impact. So technological heterogeneity among AI systems does not allow us at the moment, and maybe will never allow us, to have a single criteria to establish which artifact can be a person of law and which cannot. Then we have an intra-system legal asymmetry. Each legal field may assign a slightly different meaning to personhood, entailing differentiated rules regarding its incidence and the outcome thereof. Let's only think about criminal law and company law. And finally, inter-system asymmetries. Each country's legal system have different set of rules concerning law's person, and over which it generally exercise exclusive jurisdiction. How to solve this problem? My proposal is basically is mainly theoretical. In order to find a balance in this sort of coordination trouble, is to we should take a multi-layered ontology of the concept of legal personality, because different levels of this ontology associated with this macro concept of legal personality may correspond to different uses, also helpful for legislators and policymakers. So I differentiate in a first moment, I differentiate an institutional level of legal personality and a meta-institutional one. The institutional level is described by the use conditions and the normative implication of legal personality. But apart from use condition and normative implication, what condition and entity is described as a legal person and what consequences follow, there are also background reasons, which facts set the condition granting personality law. This other level, the level of background reasons, is a meta-institutional level. We find different concepts from personality law. So we have the institutional concept of personality, legal personality, and the meta-institutional, a family of meta-institutional concepts and reasons for assigning or not assigning legal personality to certain entities. What is the usefulness of having this meta-institutional level? Yeah, of course, through meta-institutional reasons and concepts, we can test and possibly reformulate the content of the institutional concept, the so-called de jure condendo perspective. In our case, for instance, they can serve to question who or what ought to have legal protection and in which way. But frequently, this is done indirectly, such as not referring explicitly to meta-institutional terms, but through something that I would call transitional concept, aiming to connect the broadness of the meta level, the meta-institutional level, with the substantive rules and the typical outcome of legal institutions. With respect to legal personality, I think legal subjectivity is like a transitional concept of this kind, because it describes the potential eligibility to be holder of rights and obligations. So we will end up with three different levels. A meta-institutional level where we find concepts like agency, communication skills, moral stance, but also imputability, rationality, social role, and so on. Then we have a transitional level. So at the meta-institutional level, we test the possession of certain qualities as agency, communication skills, and moral stance. But neither of these qualities are sufficient conditions for the attribution of legal personality. If it was the case, we could just figure out what this subjecthood is about, what this meta-institutional level is about, and then deciding if certain entities are worthy of entering into the market of legal subject. Instead, we should compare the possession of some kind of subjecthood of those qualities with the actual ability to use them in the legal sphere. In this way, we can balance or combine the general values with legal requirements. We assess through the notion of legal subjectivity the potential attitude to be holder of rights and duties in the light of the intrinsic characteristic of the legal system and the legal practice. But it could be also judgment of legal expediency, such as a well-deserved protection for certain entities is already guaranteed or would be guaranteed by existing rules and existing liability regimes. And finally, we have the institutional level where we find legal personality as a concrete bundle of rights and duties, so that we can tailor the best configuration of legal personality according to the presupposed meta-institutional values which have been adequately balanced and adjusted. So, to conclude, why should the jurist buy this multi-layered ontology? The practical advantage lies in the way we can employ the above concepts also to face the coordination issue I have described. Let us assume that the European legislator uses the notion of legal subjectivity instead of that of personality. In this way, she elects a center of interest capable of being the addressee of legal norms without committing to specific bundles of rights and duties. It would just express, she or he would just express the potential attitude to entitlement, or as it is often said, the expectation to personality. This hypothetical subjectivity of AI system could be tied only to few common conditions, for instance, the fulfillment of technical standards, transparency, explicability, safety, reliability, and the working context. And I think that the convergence on a common meta-institutional precondition, which in this case incorporates social and technical aspects, technological aspects, supported by a flexible transitional concept, as it is the concept of legal subjectivity, can help us to reduce the coordination problem. How? First of all, thanks to the meta-institutional common ground, we would restrict the area of potential electronic persons, maybe introducing a sort of testing procedure and a certificate of compliance. Second, no national legislator should commit to a particular conception of legal personality, and they would remain free to carve out the institutional status in detail as they see fit. And third, this would also give a legislator the possibility to determine whether the resulting personality will be of civil, contractual, or criminal law, or maybe a mixture. This kind of strategy regarding these asymmetries is possible, in my view, if we adopt a transitional concept like the one of legal subjectivity. Thank you.